So, herzlich willkommen zu unserem Zollwebinar zum Thema US-Zölle und wie geht es weiter in der Entwicklung der US-Zölle. Wir haben schon eine relativ große Gruppe an Teilnehmerinnen und Teilnehmern, die bei uns sind, und es kommen, glaube ich, noch laufend Leute dazu, aber ich glaube, ich werde jetzt schon einmal langsam mit der Begrüßung beginnen. Mein Name ist Irene Lack-Hageneder. Ich bin die Wirtschaftsdelegierte vom Außenwirtschaftscenter in Washington, D.C. Hier das Außenwirtschaftscenter Washington, D.C. Wir betreuen gemeinsam mit unseren Kolleginnen und Kollegen in den USA vom Außenwirtschaftscenter New York, Los Angeles, die Kollegin in Atlanta. Wir betreuen alle gemeinsam das Thema US-Zölle. Hier in Washington sind wir vor allem damit beschäftigt, wirklich die Trade Policy zu verfolgen und zu schauen, was gibt es jetzt wieder für Neuigkeiten. Und es gibt ja sehr viele Neuigkeiten und Entwicklungen. Und wir betreuen sie eben sehr gerne, unsere österreichischen Mitgliedsfirmen zum Thema US-Zölle. Da möchte ich auch gleich den ersten Hinweis darauf geben. Wir haben auf unserer Webseite auf wko.at einen Zollinfopoint eingerichtet, der Sie laufend über die aktuellen Neuerungen informiert. Ich werde jetzt dann nach meiner Begrüßung und Einleitung, werde ich den Link dann auch im Chat teilen, sodass Sie den auch noch einmal haben. Und dort sehen Sie wirklich immer die aktuellsten Informationen der Dinge, die gerade beschlossen wurden. So since the webinar was announced to be in English, and since our speaker is US citizen and an English native speaker, I will now switch to English because I also think that we have a couple of attendants who only speak English. So that's why I'll switch to English now, and I hope that this is okay for everyone. So before I introduce our speaker and before I hand over to our speaker and before some housekeeping remarks, I would like to give you a kind of first very broad overview of the tariff situation, on US tariffs that we're looking at right now. So let's start off with the reciprocal US tariff. We call them reciprocal tariffs or IEEPA tariffs, as some specialists know. They are at 10% for all countries worldwide right now, and they are applied right now. They were announced in April. Shortly after that, or more or less at the same time, US President Donald Trump also announced individual reciprocal tariffs for a number of countries, which were higher. They were like 20, 25, 30, 40, whatever number, higher tariffs. Those tariffs, however, those higher reciprocal tariffs were, however, paused afterwards. And they were supposed to be paused for 90 days. 90 days, this deadline was the 9th of July, yesterday. That's also why we're scheduled the webinar for today, to be sure to be able to tell you and give you the newest information. However, I'm sure you have followed the news. As of Monday this week, the US president announced that this deadline will be extended until August 1st. So August 1st is the new deadline and the next deadline that you have to look out for. However, he already sent out a couple of letters to certain countries announcing or telling them their new reciprocal tariff rate. The EU has not received such a letter and is not expecting to receive such a letter because the EU and the US are in ongoing negotiations right now. I'm sure you all follow the news. Ursula von der Leyen, she announced that she's hoping to get a result of those negotiations within the next couple of days. I think they had planned to have a result even before the 9th of July, which did not happen. But we will just see. There's no information as of today if there will be a deal and what the deal will look like, but I'm sure that we will find out within the next couple of days. So this is the new deadline again, 1st of August. We will see what's going to happen with the reciprocal tariffs. However, I should also mention that the reciprocal tariffs, as I mentioned, they're also called IEEPA tariffs. They are based on a special law that is actually being legally challenged in the US right now. So our speaker will talk a little bit more about this later on. So to be honest, I am not sure, or we are not sure about what to expect from those reciprocal tariffs in the future. And I think that actually President Trump in the future, his favorite tool when it comes to tariffs, or his favorite legal base for tariffs, will in the future be the Section 232, Section 301, or other sectional tariffs, or let's call them sectoral tariffs. I will speak a little bit later about those in more detail. So I think in the future, we will probably look more at individual tariffs focused on certain sectors and certain product groups, more than we're looking at now a broad tariff that applies to all products and all countries. So that's about the so-called reciprocal tariffs. As mentioned, there are different types of tariffs. There is, for instance, the Section 232 steel and aluminum tariff. For some reason, it's not been in the news so much. It's not been in the headlines so much lately, but it is actually a tariff that it is very burdensome for a lot of companies. It is at 50% right now, which is really a lot. So this is really a very, very tough burden for a lot of companies, Austrian companies, European companies, and US companies alike, and companies worldwide, because they apply to all countries worldwide. So those are a little tricky, and we do get a lot of questions about them because of like how are they applied, because for instance, the 50% tariffs, they only apply to the steel and aluminum content of products. So it is for raw steel and aluminum, but also for derivatives. And for the derivatives, the tariff only applies for the steel and aluminum content. So there are quite a lot of questions about how to calculate this. There's also quite a lot of questions about like the origin. You have to prove the origin where it comes from, because there are also exceptions if the steel or the aluminum was melted and poured in the US. But again, our speaker will talk a little bit in more detail about all those questions. After the steel and aluminum tariffs, I also want to mention the Section 232 automotive tariffs. If I call them, just to explain one more time, so the Section 232 is actually only the legal base that those tariffs rely on. Again, as mentioned, reciprocal tariffs, the legal base is IEEPA. Section 232 is just another legal base that those tariffs are based on. Yeah, so again, mentioned we have 25% on automotive parts and automobiles. So those are also important for Austrian and European companies, because we have a lot of companies in the sector of automotive parts. So this is also important to know. Let's also have a quick look at possible future tariffs. So as mentioned, we have those steel and aluminum and automotive tariffs, but there is also some product groups that so-called Section 232 tariffs might be applied to in the future. If the US president wants to launch such tariffs, he has to first do a so-called Section 232 investigation. And such investigations were launched into other product groups. So, for instance, semiconductors, pharmaceuticals, processed critical minerals and derivative products, copper, lumber, airplanes, engines, trucks. So there's a couple of areas where the US administration is already looking into applying Section 232 tariffs in the future. And actually just yesterday, Donald Trump has announced tariffs on copper, and they will be based on this Section 232 as well. So again, I mentioned those are the sectors where such investigations were already launched. But then there are also other sectors where the president announced that such investigations might be launched in the future. So this is all, there's a lot of things up in the air. There's a lot of question marks. There's a lot of maybes, which makes it even harder for companies and for you all to deal with this. So we're trying to help as much as we can, and keep you all informed on our website, or again, you can contact us or our colleagues at the other offices in the USA, and we will also be always in touch with our experts and lawyers to be able to help you as much as possible. So this was kind of laying the ground and explaining the base of the tariffs. I would now like to introduce our speaker, today's speaker. I'm very glad that he's with us and he agreed to be speaker for us today. Joseph Maher from the law firm Nixon Peabody. He's an extremely accomplished expert, and he knows the subject from both sides, because he has actually served at the highest levels of the US administration during 4 presidential administrations, handling various complex issues, including customs and tariff issues. So he knows the subject from the administration side, but now he's working at a law firm. He's working with a lot of companies and clients how to apply the tariffs and how to mitigate the tariffs. So he knows both sides of the topic. You have his CV, by the way, on the slide, so you should you see that already there. So thank you again so much, Joseph, to be with us and to agree to speak today at our webinar. I would like to hand over to you, but before that, just a couple of housekeeping rules and a couple of remarks. So since this is a webinar with a rather large audience, as opposed to a workshop, which is usually with a smaller group where you can ask more questions. So you're also invited to ask questions, but please just ask them in the chat in written. I will monitor the chat, and after each chapter, our speaker will take a short break so I can ask those questions for you. So please keep your microphones turned off and muted at all times, so we don't have any disturbance in the meantime. We will also share the slides of today's presentation with you. Please give us a little bit of time. We will send out the email tomorrow, and this webinar is also recorded, so we will also provide a video of today's webinar on our YouTube channel. But again, please give us a little bit of time. This will be available on our website next week. That's all from my side. I would now really like to hand over to our speaker, and thank you again, Joseph, for being with us, and thanks to the audience once again for attending the webinar.
Thank you so much, Irene, and I really appreciate the chance to talk to you and for the invitation to speak to this group. It's I know a group of a lot of people with a lot of different experiences, and so as she mentioned, there's a lot of uncertainty with tariffs in the United States, and so my goal here is to give you a kind of clear explanation of where we are today, and to give you also a little bit of information about why there are so many changes and where things might go in the future. I'll start with an overview of kind of a snapshot of where we are that builds on the information that Irene provided you. And then I'll also kind of talk about, why are all these changes happening? She mentioned there's litigation. What could that mean for tariffs in the near-term future? We'll also go through how to do certain types of tariff calculations. I'll quickly go through it so that people who may not be as familiar with it can have a baseline. But then we'll talk about some sector-specific tariffs and how calculations in those areas work. Finally, I'll mention some strategies that companies can use to try to mitigate tariffs while they're complying with the law, but also not doing what they can to make sure they're not overpaying tariffs. And then I'll also touch on enforcement. So the government's enforcement is undoubtedly going to ramp up in the coming years. The rules are very complex and detailed and fact specific, and so kind of understanding what the enforcement mechanisms are like is going to be important as you go forward. And we'll also talk a little bit about how to mitigate some of the risk so that you don't get caught in enforcement traps. So just to go over kind of a snapshot of where we are, these are some of the major tariffs that have been put in place since President Trump came into office for his second term. So one of the first things he did was put tariffs on Mexico, Canada, and China related to our northern and southern borders. These tariffs, as we'll talk a little bit later, are based on a new authority under what's called IEEPA, or the International Emergency Economic Powers Act, which he placed on immediately. There are a number of exceptions related to these tariffs that probably aren't as interesting to this audience because they're focused on Mexico and Canada, but we can touch on those briefly. China is kind of a separate issue. The current baseline for China is 55%, although it depends on the specific articles that are involved. That rate is in place until August 12th. At which place, if there's not a further agreement with the president, that'll ratchet up much higher. That's relevant, obviously, because a lot of inputs for manufacturing processes sometimes come from China, and so that's relevant. Irene mentioned some of the sector-specific ones. The auto and auto parts rates, which are currently at 25%, are in place. The steel and aluminum tariffs, which were at 25%, but are now up at 50%, which is very significant. And then, of course, probably the most important for this audience are the reciprocal tariffs that were put in place. And I mentioned those are currently at 10%, with the EU's rate to go up to 20% on August 1st if there are no other deals struck. There probably will be some deal struck between now and August 1st is my guess, or some change in that. As she mentioned, these reciprocal tariffs were set to be at 10% until July 9th. The president changed that to August 1st. And he is now, as you probably have seen in the press, rolling out letters to countries all over the world, telling them this is actually going to be your tariff come August 1st. So, for example, I have up there Japan and South Korea. He set at 25%. And the rates he's putting in these letters are not necessarily the same rates he put into the table on April 2nd for the various countries in the reciprocal tariff executive order. So they are changing kind of as these letters are rolling out. And as he's mentioned in the press, he's willing to negotiate from whatever those letter tariff amounts are if companies are willing to make certain, or countries are willing to make certain.
So I'm afraid there is a little technical glitch and I cannot hear our speaker anymore. I think he's frozen.
Projected to be. I think we probably will not know until.
Sorry, Joseph. Sorry to interrupt.
Yep.
I think you were frozen for a little while for all of us. So maybe if you can just repeat the last minute or so that what you were saying. And
sorry about that. Yeah.
Yeah. One more request. Sorry to interrupt. A person from the audience was asking whether you could speak a little slower, please, because our audience is mainly, I think, like 98% German native speakers. So if you could slow it down a little bit, please. Thank you.
Yes, my apologies. I'll definitely I'll do that. So I mentioned, I think what I was mentioning with respect to reciprocal tariffs is that the implementation of the changes is set now for August 1st. The president is rolling out letters to individual countries. He has not rolled them out to the EU yet. The letters that he is sending out to countries have various new rates in them. Those rates that he is sending out are not necessarily the same rates that he put into his April 2nd executive order on reciprocal tariffs. So, for example, he sent letters to Japan and South Korea saying that their rate will be 25% as of August 1st. He also sent out a letter to Brazil recently saying that Brazil's would be 50%, which is much different than what was he initially said on April 2nd, that Brazilian rate was supposed to be 10%. There are a number of other countries that have gotten letters. Even as we're sitting here today, more letters are going to be going out to other countries. So between now and August 1st, there are going to be many changes for rates for countries across the world, including the EU. As we mentioned, the EU's kind of default to go to on August 1st would be 20%, but that is very likely to change in some way between now and then as negotiations continue. And then I'll also just mention, you probably know this, but there are, in the reciprocal tariffs, there are certain categories that are exempt from reciprocal tariffs. So those include semiconductors, pharmaceuticals, copper. Those are exempt for now from the reciprocal tariffs. And the reason why is because I think the president is anticipating imposing new tariffs on those sectors. So in particular, he's mentioned copper and pharmaceuticals as having new tariffs that will be coming, although the details of that are still yet unknown. I want to briefly go through the authorities to change U.S. tariffs. Who has the authority to do this? And the reason why this matters is because whoever has the authority to change the tariffs is going to dramatically affect the rates of tariffs, how quickly they happen. And so I'll briefly go over this, but this has direct relevance to you because of ongoing litigation that could cancel some of these tariffs. So historically, our legislative branch, Congress, has had the authority and has set tariffs for the United States by enacting laws. The Congress, however, has, in limited circumstances, given authority to the president to impose or change tariffs. Those are usually specified in law specifically and have certain procedures that go along with it. So I'll quickly go through this, but one example is what's called the safeguards measures tariffs. These are called Section 201 tariffs. These apply if there's a determination that all of a sudden a large quantity of articles is coming into the United States in a way that damages the domestic companies producing those same articles. And so an example of when this was used are for solar panels. So there was a large amount of solar panels being imported into the United States. There was a review of that, and in the first Trump administration, there were additional tariffs put on solar panels. You can go over the slides later, but as you can see here, there are a number of procedural requirements before these types of tariffs can be imposed. And you can look through this, but the bottom line is that it usually takes months to impose tariffs like this. So from the time that someone decides there's an injury to domestic production of certain articles to the time when a tariff is imposed, there's a lot of analysis that has to be had, a lot of input from industry that's considered, and then the tariff is actually imposed. So that's very different, obviously, than what's happening in the current time with reciprocal tariffs. And I'll explain a little bit of why that is. Another authority where Congress has given the president authority to set tariffs is where there's an impact on the national security of the United States. So the two kind of clear examples of that are for the steel and aluminum tariffs and for the autos and auto parts tariffs. Those there's a determination by the president that the import of those items can negatively impact the national security of the United States because of the United States' ability to maintain a domestic production in those areas. And so he's used this authority both during his first term with steel and aluminum, and as well as his the current term the President Trump is in, to increase steel and aluminum tariffs, as well as put tariffs on autos and auto parts. Again, it takes months or sometimes years to implement these types of tariffs. There's an analysis that's done that's sent to the president. And so although he has used these, his more recent preference is to use other authority that moves much faster. Finally, another example of an area where the president has unilateral authority to change tariffs because Congress has given this to him are for what are called 301 tariffs. These are unfair trade tariffs where an assessment is done that a particular country is using unfair trade practices targeting the United States, either particular industries or the United States at large. If there's a determination that that is happening, then the president can take certain measures, including increasing tariffs, to try to reduce that those unfair trade practices. So the president did this pretty significantly with respect to China during his first term in office, where he basically put on a roughly 25% tariff on a vast majority of Chinese goods coming into the United States. President Biden continued this policy, and it currently exists now under the current President Trump's current administration. So again, these also take time to implement. These are not things that get implemented overnight or right away by the president. There has to be analysis and process that goes along with it. And now we're up to where the president's kind of preferred methodology right now, which is to invoke this statute called IEEPA, the International Emergency Economic Powers Act. This is a statute that gives the president broad authorities in a lot of different areas, but it has never been used before for increasing tariffs until President Trump used it. In order for him to use this, he has to declare a national emergency. But the thing that makes this authority very unique is that it can be done very quickly. So he can do it within a day, change tariffs under this authority if he makes the certain determinations. This is what he's basing the reciprocal tariffs on. This is also the authority that underlies certain tariffs against Mexico, Canada, and China. And there's also, importantly, litigation going on right now in the U.S. courts regarding this authority. So a number of companies have gone to court and argued before the courts that this statute does not actually give President Trump the authority to increase tariffs in the way that he's doing it under this statute. Two primary courts have heard these arguments and decided that it was unlawful to impose these tariffs this way. These are lower level courts. And so now these cases are up on appeal to higher level courts. There's a significant argument in court that's happening on July 31st. So after that happens, the Intermediate Appellate Court will decide. And then my guess is it will very likely go to our Supreme Court for a final decision. That won't happen for months. And so my guess is this litigation will probably not be resolved until at the earliest towards the end of 2025. And also very likely it could be sometime in 2026 when the courts give a final answer on this. Now, even though the lower courts have said it's unlawful, the courts have said we're going to pause that ruling while the higher courts consider it. So right now, the reciprocal tariffs are still in play. We still have to pay those. But if the higher level courts and the Supreme Court agree with the lower level courts, this is unlawful, then those reciprocal tariffs are going to have to go away. What does that mean for you? That also means that companies will very likely try to get a refund.
I'm afraid we lost our speaker one more time. I hope that he will be back any minute.
Can you hear me now?
Yes, you were gone for a second once again. Last thing we heard was that you were saying that companies were going to try and get a refund if the reciprocal tariffs are unlawful. Thank you.
Right. Thank you. So if the courts ultimately determine that it was unlawful, there'll need to be a process for companies to get a refund. So a lot of details on that to come, but that's where things stand. And so that litigation is of key importance to many, many companies, both within the United States and across the world, because of how significant those reciprocal tariffs are, in addition to the tariffs related to Mexico, China, and Canada. Okay, briefly, I wanted to just give you an overview of tariff calculations to make sure everybody has a baseline understanding of how these are calculated so that when we talk about sector-specific tariffs, you'll see what's happening. So generally, the amount of tariffs you pay are governed by three factors. One is the country of origin of the goods that you're importing into the United States. This is not the same thing as where the goods are shipped from. So the goods might be shipped from Germany or Austria into the United States, but that doesn't necessarily mean that that is the country of origin. The country of origin, we'll talk a little bit more detail about, but it's where the goods are originating from, where they're manufactured from usually. The second issue is the classification of the goods, right? What type of goods are you bringing in? And as many of you probably already know, there's a harmonized tariff schedule that each country has, and it has many, many different types of classifications for different types of goods that are brought in, and there are different tariffs associated with those different types of goods. So that's the second important element of how much tariff you're going to pay. And then third is the valuation of the goods. So this is the most of the tariffs in the United States are based on a percentage of the value of the goods at the time that they're sold for export to the United States. So when you look at these three elements, that's how you calculate the tariffs that you actually get paid. There's also another kind of layer that exists for some countries have free trade agreements with the United States. The EU doesn't have one right now. And so I won't go into detail about that. But if you're, for example, bringing in goods from Canada or Mexico, there's a specific trade agreement that has different rules applied to it. So I won't dwell on that too much, though. Tariff classifications. So that's a whole other subject of how to classify goods. But I just want to point out, two chapters of the harmonized tariff schedule in particular to keep in mind, because sometimes you can lose sight of these. One is Chapter 98, which has rules, special rules that can reduce or eliminate tariffs for certain types of situations. So I've listed a number of type of situations here that have either lower or no tariffs if you bring goods in this way. So, for example, if for example you sell a product into the United States, and at some point that product by your consumer, by your customer needs to be repaired, so they send the item back to you to be repaired in the originating country. When you bring that good back into the United States, you don't have to pay the whole tariff again. You generally only have to pay tariff on the value of the repair. So that's an example of a special rule. There are special rules for if there's scientific or educational research apparatus that are sold to, for example, universities or other nonprofit entities into the United States. Those can have an exemption from paying tariffs, which can be significant for those organizations. So if any of your customers are universities and you're selling complex machinery for them to use in their research, that's the type of special rule that can apply. And then Chapter 99 in the United States is for special classifications where there are temporary modifications to the tariff rules. Importantly, that's where all the action is for the new Trump tariffs. So those Chapter 99 classifications get layered onto the classifications for the articles that you're bringing in. And so, for example, for the reciprocal tariff, so there's a reciprocal tariff that applies, or if the steel or aluminum tariff applies, there'll be a Chapter 99 section that applies to it. Country of origin, we talked about this a little bit already. This is incredibly important to the United States as it values goods and as it applies the tariff and for enforcement purposes. So there are basically kind of two general questions to ask. One, if you manufactured something outside of the United States that you're importing, were the parts and process that you got to produce that good wholly obtained within the country where you manufactured it? If it was, then that is the country of origin. If, however, you're bringing in parts from other countries, say you're bringing in parts from China or other countries like that, and compiling them into your country and then bringing it into the United States, you have to do an analysis as to whether the country of origin has changed for those parts. And there's a test called the substantial transformation test that the United States uses to look at to see when you did your manufacturing in your country, did you substantially transform the parts so that what you are bringing into the United States has a unique character or name or things like that? Just to give you an example, if you are assembling an article in your country and you buy the parts of that to use for that from China, and it's a very simple assembly process. You're just putting 2 or 3 pieces together, and then you're selling that to the United States. That type of simple assembly is generally not sufficient to change the country of origin. So the United States is going to view the country of origin of that good as China, which means all the tariffs and rules apply to that as if it came from China, not from whatever country you're sending it from. So the test for this is very fact specific. It includes factors like, how much did it cost you to manufacture the item? How complex is the manufacturing process? Are the parts that you're putting into the process, have they changed in some way? So it's a detailed analysis that needs to happen depending on your particular manufacturing process. Okay, valuation. This is also an incredibly important part of how much you end up paying. So generally, the value is the value of the article at the time of sale for export to the United States. The United States has a law that specifies the type, how you do the valuation, what methods you use to evaluate it. For the vast majority of goods, there's a transaction value is the valuation method, which basically means if company A sells a good to company B, there's an invoice associated with that. That invoice is generally going to have the transaction value, and that is used to value the good. Where this comes up and where this deviates oftentimes is if the two companies are related parties. So if your company outside of the United States has a subsidiary that is a U.S. corporation that you sell your goods to, and it's a subsidiary of your company, that's a related party transaction. And so the invoice or transaction value is not necessarily going to apply. There's a burden on the company to show that the fact that the companies were related did not affect the price or the value of the good coming into the United States. Why does this rule exist? It exists because to avoid allowing companies to just significantly mark down the price they're going to sell an item to a related party, a subsidiary, in order to reduce the value and reduce the tariff. So there are a number of other types of valuation methods. There are 6 of them listed in the statute that you can use if that's not an available valuation method. And that can become very detailed, but I can take questions on that if you have questions on that. To move to some of the sector-specific tariffs that are in existence now, and before I move into this, let me pause just for a minute to see if there are any questions, and if not, I'll continue on, but I just want to make sure I'm not kind of glossing over things if people have questions. Let me take 10 seconds to see if there are any.
So far, I don't have any questions in the chat. So let's continue a little while and then see if there's anything. Thank you.
Okay, great. So as I'm sure many of you are aware, President Trump recently increased the steel and aluminum tariffs to 50%, which applies worldwide to all countries, except there's a special tariff for the UK under an agreement, which is 25%. So generally, freight and insurance are not the part of the valuation. So there are special rules for things that can be excluded from the valuation. So the cost of getting the good to the United States is generally not part of the valuation. So there are other things that can be part of the valuation. So if, for example, the company that is importing it into the United States provides what are called assists to the selling company outside of the United States, that needs to be included in the valuation. But generally, kind of the cost of transport is not. So hopefully that answers that question. So the aluminum tariffs and steel tariffs apply to which type of articles these apply to are listed in the executive order. So it includes derivative products, and whether your product constitutes a derivative product depends on whether the classification code for your product is listed in the executive order. There's some special rules associated with these, not allowing drawback, things like that. The other thing to know that's important is you only pay this tariff on the steel or aluminum content of the good. So with the new tariff increase to 50%, one of the other adjustments that President Trump made is that for any goods that qualify for this tariff, if there is a component of the article that is not steel or aluminum, then you don't apply the steel aluminum tariff to that component. Instead, the reciprocal tariff applies to that component. So if half of your good, 50% of your good is made of steel, for 50% of the valuation of the item, the steel tariff will apply. For the other 50%, the reciprocal tariff will apply. Okay. So what this means is that there are multiple tariff rates that can apply to just one item that's coming in. And so this is kind of obviously ramped up the complexity for companies. It's also ramped up the complexity for the U.S. Agency that administers this, U.S. Customs and Border Protection, and they've adjusted their computer systems to be able to accommodate the additional complexity. So the question, I saw a question, is there a list for all steel derivative products? So yes, there's a, for the executive order that deals with the steel tariffs, there's a list of which classifications under the harmonized tariff schedule qualify as derivative products for steel. So the answer is yes to that. Okay.
May I jump in for a second, interrupt, and also answer that question? We have posted the link to our website, the Zollinfo Point, and also on the Zollinfo Point you can find all the legal basis, so all the executive orders that Joseph was mentioning, and also the list of the products. So you will find all that on our website. Sorry to interrupt.
Yeah, absolutely. And just to add on to that, the list of derivative products can change, so they can add items to it. So if you're looking at this, just make sure that you find out whether there's been an addition to the list that adds additional classification codes. So the idea there is that if the Secretary of Commerce or the President thinks that certain industries are trying to get around the steel tariffs by using other products, they'll be able to kind of adjust that list. So just a point there. I wanted to talk a little bit about one of the more complex issues associated with steel and aluminum tariffs, which is how to determine the value of the aluminum or steel content. There's a lot of confusion, I would say, in the trade about this issue. Customs and Border Protection, the agency that administers this rule, has issued guidance, and so I put the guidance they have up here. This guidance, however, is not specific in ways that are helpful. So just generally to walk through, I'll let you read it on your own later, but it generally first refers to this statutory provision, section 1401A, which is the general general statutory rule about valuation. So it points and says the general rules apply to how you value this content. Then it goes on to say, though, that the value of the steel aluminum content is the total price paid or payable for that content made by the buyer to the seller for the aluminum or steel content. The reason why this is not very helpful is because it doesn't specify who the seller and the buyer are that this guidance is referring to. And there are two alternatives that it could be. The seller and the buyer and the seller could be, in one example, what is generally correct, which is the importer in the United States is the buyer, right, of the article that you're selling to it. So this could mean that this is the buyer is the U.S. importer, the seller is the foreign manufacturer, and so you look at the price that the importer is paying for the steel content. That's one way of looking at it. Another way of looking at it is that the buyer refers to the foreign manufacturer who buys steel or aluminum from some other foreign entity, and the seller is the seller of that raw material to the foreign manufacturer. And so whether you look at it one of those two different ways, that has different answers for how you value this. So I think a number of other people have asked CBP to clarify this issue. I have not gotten a response back yet. My guess as to why that's happened, typically CBP is faster in coming out with responses to these things. My guess is that because of the unique way these rules are being created, very top down from the President of the United States, kind of dictating these rules, is very different than typically how this is done. Typically, there's a regulatory process where the agencies develop the rules with guidance from the political leadership. There's input from the industry. Questions like this would have come up and answers would have been developed. But I think CBP is probably very cautious about not wanting to get out of step with where President Trump's intentions are. So anyway, that's my kind of sense as to why kind of better guidance hasn't been coming more quickly on issues like this. So let me pause there because I saw a couple of questions pop up, but I don't see them right now in front of me, but I can take a few questions if there are any out there, that you want to highlight.
Yes, absolutely. So the last question that came in was, do we have to consider the content of aluminum even for aluminum containing chemicals?
That is a good question, which I don't know the answer to.
I would say the answer is it depends on the exact product, because if it is, I would think that aluminum containing chemicals are probably not on the derivatives list, but it really depends on the specific product. So you will have to look at the tariff number, or you will have to look at the code of the product and then see if it's on the list.
Yes, that's definitely correct, and I should have mentioned that. That's to look at the classification code for your specific chemical that you're importing in the United States. See if that is listed as a derivative aluminum product, and if it is, then that would apply. The reason why I hesitated is because there's a separate issue, which I won't dwell on unless people want to ask about it, which is that there's a heightened tariff for aluminum from Russia, which is a 200% tariff. And so that has implications for all kinds of goods that come into the United States that contain aluminum. So I won't dwell on that, but yeah, Irene is exactly correct. In terms of looking at the steel and aluminum tariff and whether that applies, it depends on the classification code and whether that's a listed classification code for under the executive order. So that's something that's pretty easy to find out. Yeah.
So
okay.
We also had the question, but I think it's already answered. Is there a list of derivative products or all steel derivative products? So you answered that question, and I also posted the link to our website, and again, as mentioned, we have all the sources and the links to the sources on our website, because as Joseph, you mentioned, things change so quickly. So that's why it's always better to post the link to the direct source than to kind of copy paste the text into the website to be sure that it's always up to date.
Yeah. And I'm mindful of the time, so I'm trying to pick up my pace a little bit. But the other thing I want to mention about steel and aluminum tariffs is the president has taken the very unusual step in his executive orders of giving specific direction to CBP, the enforcement agency, to basically tell them to enforce this very strictly and to impose the maximum penalties if they think that companies have misreported their steel and aluminum content. I want to highlight this because I've never seen this before from a president. Typically, the enforcement agency, if they think you've misreported something and paid too little tariff on an item, and they catch that, they will start a review process where they say, hey, we think you got this wrong. Explain to us why you don't think you're wrong. There's a back and forth. Penalties will be imposed. And usually there are different factors they take into account. So if you have not had violations before, it's the first violation you've had. Different factors like that can work to reduce the amount of penalty that you'll have to pay. But anyway, the president has taken this kind of unusual step of saying, do the maximum penalties, be very strict with your enforcement on this. So I say that just because there are a lot of companies are thinking of ways they can try to get around the tariffs and like that. These are legitimate. As long as you're following the law, you should try to minimize the tariffs you pay. But if there's our interpretation kind of in the gray area, this can be a more dangerous area to kind of roll the dice on. So I wanted to mention that specifically. The other kind of another major sector specific tariff is obviously auto parts. There are some special rules that apply to the U.S., Canada, Mexico agreement for automobiles, where a lot of the United States automotive market happens. I'll save that for later because it probably doesn't apply to many people here. The auto parts, for example, if you're wondering whether a good that you're selling into the United States to an auto manufacturer qualifies under that, you have to look to see whether the classification code for your item is listed as an auto parts. The other thing I'll mention is that in April, the president augmented the auto tariff rules to allow an import adjustment offset. So when automobiles are assembled in the United States using parts from outside of the United States, the president has set up a system for 2 years where there can be an offset for automobiles being assembled in the United States to reduce those. So I've put some rules here. I'm not sure whether that affects a lot of the people on this call or not, but I can take some questions on that if you'd like afterwards. Basically, this allows the auto manufacturers who are assembling in the United States to kind of pass along some of the reduction in tariff to auto parts suppliers that are supplying their assemblies. Okay. Tariff stacking. So there's an separate executive order that discusses how all of these different tariffs interrelate, when you do and when you don't have to pay multiple types of tariffs at the same time. Some of these rules can be complex, so you really have to pay attention carefully to that executive order to assess. So I listed a couple of specific items here. So if goods are subject to the auto parts tariff, the steel and aluminum tariffs generally don't apply. Articles can be subject to both the steel and aluminum tariffs at the same time. So if your article has both steel and aluminum in it, both of those tariffs can apply to it. You look to the steel and aluminum content to divvy those up to calculate the tariffs. The reciprocal tariffs, they don't apply in certain contexts. So, for example, when they're for the auto, if the auto parts or auto tariffs apply, there's no reciprocal tariff that applies to that. Same with steel and aluminum content. If the steel and aluminum tariff applies for the contents that is steel and aluminum, you do not have to also pay the reciprocal tariff. You only pay the reciprocal tariff on the non-steel aluminum content. Other exemptions from the reciprocal tariffs we mentioned before: semiconductors, copper, and pharmaceuticals. Those are exempt from reciprocal tariffs with the idea that those specific sector tariffs are likely to be coming soon. There are other tariffs that are cumulative. So, for example, if there's a 301 tariff that applies because the good is originating from China, that gets added on to other tariffs. This is just an example. Let me move to just mentioning a number of strategies to reduce tariffs. So one of the ways that you might be able to reduce tariffs is to do what's called tariff engineering. So that means if you have a particular article that you're exporting to the United States, if you change that article in some way that is not a negative change for your business purposes, but it might change the article enough so that it has a different classification code. And if the classification code changes, that might mean that certain tariffs don't apply to it. So, for example, the auto parts list. If your item you're sending in is classified on the auto parts list and the auto parts tariff applies, you might be able to change that item in a way that means that it gets classified differently and is no longer on the list. And the tariff wouldn't apply. So that's a valid way to mitigate tariffs. You have to be careful though, because you have to make sure that it doesn't cross the line into evading tariffs, which can cause penalties. And just kind of one very significant example of that, which if you follow this area, you may be aware of, is the Ford Motor Company recently had to pay hundreds of millions of dollars for tariff engineering that it tried to do when it was bringing vans into the United States. So cargo vans and personnel transport vans. Sorry, hopefully I'm back.
Yeah.
I think I froze for a minute.
Yeah, you're back. Thank you.
So just picking up on the Ford example. So what Ford did was it imported vans used to move people in the United States. They had bench seats in the back, windows. As soon as the articles got into the United States, they stripped out the seats, changed them so that they were then sold in the United States as cargo vans. There's many years of litigation that happened with that. Eventually it was settled, but there was a very significant penalty settlement that was paid by Ford for that. So my point here is that tariff engineering can be valid in some circumstances, but you have to be careful in how you do it so that you're not inadvertently causing yourself to be penalized. And it's kind of fact specific. Supply chain adjustments. Sometimes if you can adjust the country from which you are purchasing parts or goods from before you import them into the United States, that can change the country of origin. So obviously there are a lot of business considerations that go into whether you can do that. That is definitely one thing a lot of companies are doing and looking at right now with the changes. Collaborate with R&D during design and development. So if your research and development department in your company is designing new products to be sold into the United States, there may be ways that they can design it so that it avoids certain tariffs, but doesn't degrade the value or the use of the good that you're producing. So kind of being in earlier with the people who are designing your products and having the tariffs in mind can be a useful way to mitigate your tariffs. And then a little bit more advanced are use of foreign trade zones, duty drawback. So if you are bringing goods into the United States, but then will be shipping them to another country afterwards, foreign trade zones offer a way for you to physically bring them into the United States without paying tariffs. And as long as they are exported to another country, you can avoid having to pay tariffs. Or sometimes you can defer the duty that you pay on them as long as they reside in the foreign trade zone in the United States. you only have to pay the duty, you only have to pay the tariff after it leaves the foreign trade zone and is entered into U.S. markets. So those are a number of different ways. I know we're getting close to the end of our time, and I won't go through specifically because of time all the different penalties, but I've listed the different penalties and the different enforcement issues here in a number of slides. So there are a few things that Customs and Border Protection is especially watching out for right now. One is what's called transshipment or origin washing, where companies will want to bring goods from, especially from China, into the United States. They know the tariffs are very significant, so they will send those goods to another country, and then from that other country, enter them into the United States, claiming that the country of origin is no longer China. CBP has very sophisticated ways to investigate that, and you can get penalized very significantly if you're doing those kind of things. And if you're doing it in a way that the government thinks you're defrauding the government, there can be not only very significant monetary penalties, there can be criminal penalties associated with that. They can also withdraw your ability to bring goods into the United States in general. The other thing that Customs and Border Protection looks for are different types of, if all of a sudden your classification or valuation is being changed. If you've been importing the same good in the United States for years, and all of a sudden you're now classifying the goods in a different way, or you're valuing things in a very different way, that can sometimes trigger alerts on the enforcement agency side, and they will come to you and ask for more information about why that change has happened. They said I'm going to let you kind of look at some of the penalty issues that are here. The penalties depend on the type of reason for why you misvalued or misclassified something. If it's just because of negligence, you were not very careful, the penalty is lower. If they think that it's willful, that you're trying to willfully state the wrong things to the U.S. government, the penalties are increased. These are some different types of false statements. There are a number of different statutes that set penalties for individuals or companies that are involved in providing false information for customs-related purposes. And just finally, I'll end with ways to try to mitigate your risk. One is by making sure you document changes. So many companies, for good reasons, are reviewing their classifications, how their items are classified, so that to make sure that they're not overpaying. Before January of this year, there were a lot of goods that if you misclassified it, the tariff rate probably wasn't different, or the tariff rate would have been the difference in tariff rates would have been very minimal. Now, a change in classification means the tariff rates can be wildly different. And so companies are going through and they may have classified an item a certain way 10 years ago. And when they're re-looking at it, they're realizing, oh, that classification is no longer correct. And we're overpaying on our tariffs. It should be classified in a different way. And so they want to change that classification to an article that has a much lower tariff. That's a valid thing to do, obviously, but you want to document why you're doing that, so that if CBP says, hey, we noticed you're changing this classification, we need to understand what the product is and why that changed. You have documentation showing we did an analysis of this issue, and here's why the change happened. We mentioned before, Chapter 98 has a lot of special cases where you can reduce or eliminate tariffs. A lot of times for those, to qualify for those, there are things you need to document. So making sure you have the documentation for that in order. Another thing is to be proactive. So if you're a company that has a list of things that have been classified and you've been importing for years, but you haven't reviewed that in a long time, you should be proactive reviewing those classifications to make sure that they are accurate and make sure they're up to date. And finally, I'll mention there's an idea called prior disclosure, where say that you realize after reviewing your customs practices that you're doing something wrong. For example, I had a client once where they had a subsidiary in the United States that they were selling goods to, and they routinely gave a significant discount as they were selling that good to the United States subsidiary that was importing it, but never reported that to Customs and Border Protection. That means that they were misvaluing the items. If they were selling the same items to another company that was not associated at a higher price, that's actually the true value of the good that they're bringing into the United States, not the discounted value. And so if they've been doing that for years, they realize this. One of the things you can do is you can go to Customs and Border Protection and say, we realized that we have miscalculated this, and so we are going to recalculate it. We're going to pay the tariff difference that we should have paid. And if you do that before CBP starts an investigation of you, you can get a reduction in the penalties, which can be significant. And so that's a way to kind of affirmatively go to them and make that disclosure. It's called a prior disclosure. That's a voluntary thing, so it's not legally required that you do that, but it can significantly reduce your penalties if you are likely to be penalized because of misreporting. So let me end with that and open it up for questions. I know we're past our time, but I'm glad to stay on for a little bit if there are questions I can answer. And feel free to reach out to me. Also, I think my email was on one of the slides. So thank you very much, Irene.
Thank you, Joseph. So first of all, thank you so much for this interesting presentation. There was a lot of information, but the topic is, I mean, you could talk for days and hours and months about this topic because there's so much going on and so many details. So obviously we were only able to touch certain points, but again, our office, our sister offices in New York, in NA, together with our legal experts, our partners, we're always there to help you and answer your questions, even after the webinar. There is one question, Joseph, if you don't mind, that is still in the chat. So one was, do you have a resource for valuation method for subsidiaries? Because you had mentioned that.
Yeah, so if you have a related company that you're selling to, sometimes you can use the transaction value, but you have to be able to show that the transaction the pricing you're doing is a price that's not affected by the fact that you're a related party. And that's a fact-specific inquiry. So if the bargaining happens at arm's length, that is, there is actual bargaining between the two entities that goes on to set the price. You can sometimes use the transaction value. You should, if that's happening, you should be able to point to other transactions between other companies that are happening to show that your price is similar to those. Now, if you can't do that, or if you don't want to, you get to set the price. If you want to give a discount to a related party that you're selling to, you can do that. You just have to move down and use one of the alternative valuation methods. And so the statute lists out, I mentioned 6 different types of valuation methods. The next valuation method you would use is to see, are there identical products that are being sold, not between you and your subsidiary, but between other companies into the United States. If those do exist, then that value is the value that applies. Or if there are no identical items that are being sold in the United States, you would look to see if there are similar items. If there are similar items, that would be the basis. If there are no similar items sold in the United States, then it gets more complex. There are a couple of different methods. One is called the deductive method. One is called the computed method. And there you have to look more into, for example, under the computed method, you're looking at the foreign manufacturer, what the costs were. So you would add up things like the raw material costs, the labor costs, the manufacturing processing costs, the profits that the manufacturer takes, and you'd add those things up to build a valuation for the item. So those are alternative methods to be used if you do have a related party and the actual price that's being paid is affected by the fact that you're a related party.
All right, thank you so much. So this brings us to an end. Oh, I see there's quite another question. Okay, just one more question if you still have time. So could I suddenly or simply change from a regular value to a transactional value? Not sure what that means. Transitional value. First, say transactional value. It's supposed to mean first sale rule, or what documentation is needed?
Yeah, so typically for the vast majority of imports, the transactional value is the method that's used, which is basically the price that's actually paid. The invoice shows the price that's paid, and that is the value that you would use. The actual price that you're selling can change based on market conditions for business reasons. So that's not a problem. If your price changes, it's just the value that applies to that.
Okay. Sorry, I didn't want to interrupt you.
No, so I saw a question about the first sale rule. So that can get pretty detailed. So I can kind of take questions offline about that. But the idea is that, as I mentioned, the value that is supposed to be used is the value of the item at the time it's sold for entry into the United States. Because that's the standard, that may or may not be the price that as the good enters the United States. There can be what's called a first sale, which is the first time the item's sold from the foreign manufacturer with the idea that it's going to be imported into the United States, even though that first sale isn't the last sale that happens to import the item. So I think that's what the question was about. And the rules around that are somewhat complex, and it's more detailed probably than I can get into right now. But I can take questions offline about that. So.
Perfect, thank you. I saw another question that was, is there a possibility to apply for a tariff exemption if it is proven correct that there's no US manufacturer who needs to be protected?
So for most of the tariff rules that President Trump has instituted for in his second term, generally there is not that ability. During his first term, for certain types of tariffs, there was the ability to go to the government, try to get an exception. This most often happened if a U.S. importer basically went to the government and said, there's this huge tariff on this particular type of article. There's nowhere else in the world that we can get that article other than this country, or there's no way for the U.S. to manufacture this article. And sometimes exemptions were applied for that. For the ones President Trump has instituted this time around, though, that's not available. So that could change. Things change all the time with the way he's implementing tariffs. So that's definitely something to keep your eye on going forward. But for right now, the steel, aluminum tariffs, for example, things like that, they don't have that ability to do that. So.
Yeah, so there's no procedure in place right now. There's no way to do that. But then again, if there is a Section 232 investigation, that's actually the time when companies can prove that a US manufacturer does not need to be protected. So that's actually the time, but you cannot apply for an exemption afterwards. The tariffs are already put into place.
Yes, exactly. Yep. So for under a number of these different types of 232, 301, those are when those analyses are being done by the agencies, that's the time when companies can go to them, try to get more information, explain why a tariff on their particular area wouldn't make sense. That's right.
Yeah. All right, so I think we'll come to an end because there are no more questions right now. I think I saw all of them. We answered hopefully all of them. So let us come to an end. Thank you so much again, Joseph, for being our speaker today and for helping us out with many questions that we do get from companies that we cannot answer ourselves. I think We'll be in touch definitely, because there's going to be a lot of things happening during the next couple of weeks, months, even years during the rest of the Trump presidency. I think it's not going to be boring. And yeah, we're trying to help companies again as much as possible. Sometimes I just have to say it is very hard because, as Joseph mentioned, sometimes there is no answers because CBP is confused as well. If there's like new rules coming out, some things happen very quickly. And as Joseph mentioned, it is very top down. So sometimes the CBP doesn't want to get it wrong. They want to make sure that they do what the president had in mind. But sometimes I think maybe you agree, Joseph, they don't know what he had in mind exactly. So it can get very complicated. Yeah. So thanks again to our audience. We will send out the slides and you will find the recording on our YouTube channel. Is there anything else you would like to add, Joseph?
Nope, just thank you very much for having me. Really good questions, and it's really a privilege to talk to an audience like this. So thank you very much.
Thanks. Have a good rest of your day, everyone. Bye-bye. Wiederschauen.